as far as food stamps and all that, I wouldn't even know how she'd qualify for any of that stuff. She makes as much money as I do.
The parties' income combined is over $93,000 a year.
In the matter of the marriage of Sherry E. Mosher, petitioner, and Nicholas Patrick Mosher, respondent, case number 22 DM 212. The petitioner Sherry Mosher does not appear. Respondent Nicholas Mosher appears by phone. Brandy Ridgeway appears as counsel for DCF. We were last before the court on February 3rd. At that time, both parties appeared. Ms. Sereti was appearing for DCF. It was announced at that time that we just need to get the journal entry done from the March 19th hearing from last year, which was the party's parenting plan. I still don't see that an order has been filed adopting that parenting plan. Mr. Mosher, have you submitted anything?
I have not. I kind of gave that to her. It doesn't really benefit me one way or the other. She has not had an opportunity to finish typing that up, which is, I believe, what she said she was going to email you today, and would ask for another 30 days to get that in order.
Ms. Ridgeway, it's my understanding, at least from the docket notes, that Ms. Sereti was going to journalize the child support obligation, but perhaps was needing the journal entry adopting the parenting plan to be able to do so.
Yes, Your Honor. Right now, the court-ordered parenting plan is for 50-50 shared custody with shared expenses. The proposed parenting plan gives the mother sole custody and allows the father, I think, every other weekend parenting time in the holidays is divided out. But based on the existing order, child support, would be shared, or I'm sorry, would be on a shared plan. And that's not what the parties seem to be exercising right now.
Okay. Well, the issue being, and I know DCF came into this after that had already been done, but it was announced on the record back in March 19th. We just don't have the journal entry from that done yet. So I think what I'm going to do at this point is we need to get this matter wrapped up. I'm just going to prepare an order adopting that proposed parenting plan that's in the file, and I'll do that myself.
Well, according to my child support calculations, child support would be $952 a month. Based on that, I know the proposed parenting plan is that they share expenses, but since they are not sharing custody or sharing parenting time on an equal basis, the shared expense plan does not apply. It would be calculated based on the mother having residential custody. And the DCF's concern is that the parties' income combined is over $93,000 a year, but with their proposed plan of no child support, the taxpayers are footing the bill for the children's food stamps.
Okay. All right, Mr. Mosher, anything you would add?
Yeah, I don't understand how they're even qualifying for food stamps. I'd say the DCF needs to drop the case.
Well, the problem is right now it's based solely on the mother's income with no child support being ordered, because that's what the current court order is.
Anything else, Mr. Mosher? All right. Well, I'm gonna prepare the order adopting the March 19th agreement, which is the proposed parenting plan that was filed with the court on May 8th, 2024. And just so that'll put a bow on that piece of it. And then Ms. Ridgeway, any recalculation that needs to be done can be submitted. And then if the parties want to litigate that further after that's all been done, then that'll be up to them to submit whatever appropriate motions.
Okay, Your Honor.
Your Honor, I don't fully understand what that means.
It means we've been waiting since March 19th of 2024 to have an order, a journal entry adopting what you all agreed to. And since that hasn't been done by either you or Ms. Mosher, I'm going to file the order adopting that so it can be done. And then the child support is what it is based on what you all have agreed upon as far as the parenting plan. And DCF is going to submit that order.
Does that mean that it changes from what we agreed upon?
I'm not sure how it will shake out in the end.
From DCF's point of view, Mr. Mosher, yes, it will change. The law doesn't allow you to agree to a shared expense plan. So we'll be calculating child support based on the custody that you're actually exercising.
Then I would want to withdraw any of the proposed plan at all figured on March 19th. And I would say the plan is now 50-50 custody. The reason that we did this was because my parenting powers were taken away by the court themselves. And in order to get any parenting time, I had to get her to agree to a plan, which I did, at which point she basically quit paying her lawyer. Now, out of good faith, I'm willing to stick with the plan, but if it's changing, then no, I think it should be 50-50 custody. During this time, she moved the kids out of the town, to a different school. It put me in a position that the only way I could exercise my parenting powers was to pull the kids out of school for a third time and force my will that way. So in order to keep the peace, okay, I invented a way that was conducive to what I believe would be best for everybody. As far as food stamps and all that, I wouldn't even know how she'd qualify for any of that stuff. She makes as much money as I do. So I really think that there's whatever is going on with the SRS. I don't quite understand any of that. But at this point, no, I would not want this order to continue.
It is what the court ordered. It was just never journalized. So I'm going to prepare the order adopting it. Then if you want to file a motion to modify that order, then that's something you can do, Mr. Mosher. It's just basically housekeeping, cleaning up what's already been ordered that's never been journalized and placed in the court file.
Okay. I mean, there's nothing I can do. I mean, if that's what you're going to do, then there's nothing I can do about it.
I'm not going to set an additional hearing at this point. I'll get that order done and filed, and then Ms. Ridgeway, if that gives you the information you need to file whatever you need to, then you can just go ahead and do that.
Yes, Your Honor. I'll file another motion and set it for a hearing on Judge Murphin's docket.
Okay. All right. If there's nothing further, we'll be in recess. Thank you, everyone.
Thank you, Judge.